Good morning, good evening, good afternoon. Happy Wednesday. It is raining and I'm under a solar panel awning. So the drum beat that you hear is the large droplets coming down from the solar panel. So on the Chile trial day two more cops were called by Chile's attorney. Those are hostile witnesses. I know somebody thinks I don't know what a hostile witness is. A hostile witness is a party opponent that you call to testify. How you deal with them is basically you deal with them on your direct as if they were on cross. So you get a little bit more leeway on like leading questions and things like that. So they're handled a bit different than a normal witness would be. So like if me calls one of the officers to testify, Michael Me, Chile's attorney, calls one of the officers to testify, he can ask them a leading question. Whereas if he calls Chile to testify, since Chile's not a hostile witness, he can't ask Chile well, I guess he can ask Chile a leading question, but then defense counsel can object that it's leading and the court would likely sustain the objection. So Chile has not testified yet. So, we'll see what happens when he testifies. Apparently he put out a video yesterday talking about how you always lose a district court and you have to appeal. That's the only way it happens. And he's going to appeal all the way up to the Supreme Court. Well, let me just, for the record, say that your odds at trial, if your odds at trial, let's just pretend they're 50-50. Let's just pretend you have a 50-50 chance of winning at trial. You don't, generally speaking. But if your odds are 50-50 at trial, your odds drop dramatically on appeal. Because it is very hard to appeal factual determinations by a jury. Very hard to do that. And so what you can discuss on appeal is very limited, just to issues that you preserved for appeal. And so your odds of prevailing on appeal drop dramatically. Like if you had a 50-50 shot at trial, you might have like a 2 or 3% chance on appeal. Most appeals are decided in favor of the prevailing party at trial. Most appeals go that way. Judges can make mistakes, juries can make mistakes, but mistakes are the exception, not the rule. And then as far as appealing to the United States Supreme Court, first of all, you don't appeal to it. You petition the Supreme Court to hear your matter. You don't have an appeal to the Supreme Court by right. You have an appeal to the Court of Appeals by right, but you don't have a right to have the Supreme Court consider your case. It's something like 99% of petitions of certiorari, which are very expensive to do, are denied. And once you get to the Supreme Court, your odds of prevailing at the Supreme Court are, again, if you manage to get there, your odds of getting there are basically non-existent. But your odds of winning when you get there are, again, very low, because you got to remember that most judges know and understand the law. Maybe they're not the best in the world, but federal judges, in my experience, tend to know and understand the law. Circuit courts, the circuit court judges, really tend to know and understand the law. And you also have to remember that the judge at the trial court, to assist the judge in understanding the law, most likely has at least one, if not more, law clerks, which are trained, practicing attorneys, who assist them with legal research to make sure that the judge isn't overturned on appeal. Because judges, generally speaking, don't want to be overturned on appeal because they have a hope and a dream of someday getting moved up to the Court of Appeals position. In the Court of Appeals, you have, generally speaking, 3 judges, if not more. It could be heard en banc. So you have a lot of very very educated, very competent people who are looking at the matter, who very competently understand the law, who have teams of law clerks that assist them with their understanding of the law. I mean, it's just, if your trial strategy is to lose at the district court level in the hopes of winning on appeal, like that is a losing proposition. If you lose at the trial court, good luck. And appeals are expensive. Attorneys don't take those on contingency because there's no winning. Best case scenario for Chile would be to have it remanded back to the trial court to make a ruling consistent on whatever. So the trial attorney, who's probably on contingency, would end up benefiting from that. But the appellate attorney would, cash up front, baby, you know. I do think that Michael Mee took this case on contingency. I doubt that Chile would want to pay the hourly rate to do this. And I am told that Chile has stated that he got a $10,000 settlement offer, which is not unusual. It's basically like, you know, here's something, just go away. That, you know, the city would have anticipated spending on 3 attorneys, if not way more, to conduct a multi-day trial. So it is probable that they made that offer. I see no reason to believe they wouldn't. And I'm sure Michael Mee would have loved Chile to have accepted that offer, even though he would have only gotten like maybe a third to half of it. And he's probably done a lot more work than the $3,300 to $5,000 he would have received. But he wouldn't be facing a multi-day trial where he would anticipate getting nothing. I'm sure that Michael Mee walked in there thinking that, well, you know, I'll push him for a cost of trial kind of settlement offer. You know, they're looking at spending, you know, $25,000, $30,000, $40,000, $50,000 to go to take this through trial. Maybe they'll just give Chile that money and, you know, I get my cut and everybody's happy. We could walk away. But apparently it didn't work out quite the way Michael Mee was anticipating. Michael Mee did nothing to prepare an argument for damages, to show damages. There probably weren't any damages to show, so, I mean, I can't really fault him. If there aren't damages to prove, then you can't prove damages. So, you know, but medical experts that Chile would have had to retain are expensive. Chile probably didn't have the money to retain those experts. I mean, it's not unusual to see him charge like $750 to $1,500 an hour for a qualified medical doctor to testify. He doesn't have a law enforcement expert to explain use of force, explain the training the officers received. Nothing. He's got nothing. He's got nothing to prove damages. So it's... And for those of you who are saying, well, he was put in jail and, you know, a court of appeals judge or whatever, district court judge, circuit court judge, whatever they call him in Nevada, ruled that he had a constitutional right to do it. That's all off the table. To the best of my knowledge, there was a motion for summary judgment where the issue of wrongful arrest was granted and was dismissed. It was the motion for summary judgment was granted as to that part. And so there's no wrongful arrest. So him going to jail, the arrest, there's no argument there. So he doesn't get damages for the wrongful incarceration. He could get damages for excessive force and a few other things, but not for that incarceration. So there's no damages. $150 for a dock in the box, meh, you know, I got a bruise, meh, you know, I got punched in the balls. Well, you know, how much did that cost you? Did they rupture a testicle? Like what happened? He's got no damages. It's hard for laymen to understand. Damages doesn't mean I got hurt. Damages means money. Damages is, in legal terms, damages are money. The harm is different than the damages. The harm is you got punched in the testicles. The damages are what money will make you whole. Damages are money in legal speak. So, like, this is just a giant clusterfuck, a giant waste of time. Michael Mee is probably just pissed that he's locked into this trial on this because he thought he was going to get hopefully a a quick settlement and make all this go away and pocket the cash. But here we are, day 2 into a multi-day trial. And the defense hasn't rested yet, so it's probably at least 5 days, if not 6. As far as Michael Mee having called the officers, the defense gets to call them again. Because since Michael Mee, Chili's attorney, called them as hostile witnesses, the defense is limited on their cross-examination to what Michael Mee raised in Michael Mee's direct. So if there are any issues that the defense wants to get in front of the jury that Michael Mee didn't cover, they get to call those officers again. Round 2, second verse, same as the first, a little bit louder and a little bit worse. So, this could 5 days would not be unreasonable, and it might even be longer. And then on a different note, somebody in my comment section essentially said that if they win the lottery, they're going to hire 5 bounty hunters to go grab Chili and bring him back to whatever state or states he has bench warrants in. If you don't understand the law, it is probably not advisable to make statements like that on social media, where if anything ever does happen, you become a suspect, because what that person is talking about is kidnapping. And if that kidnapping involves taking Chili across state lines, it becomes potentially a federal offense as well as a state offense, multiple state offenses, perhaps multiple federal offenses, not to mention the conspiracy, blah, blah, blah. Bounty hunting is not what you see in video games or Old West TV shows or movies. It's not some poster where, wanted $25,000 dead or alive, right? That is not what bounty hunting is. Bounty hunting is based on a contractual relationship between the bail bondsman and the bail jumper. The bounty hunter is an agent of the bail bondsman who has that contractual relationship, who has an agreement with the person they provided the bail bond for. And their agent, acting as their stead, as the master, has all the rights that the bail bondsman would have to enforce that contract and to bring that bond jumper back to court. Oftentimes, bail bondsmen can operate across state lines. There are some states that don't allow it. Some states do. If you're a bail bondsman, you're probably aware of what states you can and can't operate in, and what states you can operate in to collect from out-of-state bond skipping. But if you don't have that contractual relationship with the person who has a warrant out, I don't think Chili has a bail bondsman. I don't think he's paid a bail to have a bond posted for him on any of the cases where there are warrants, bench warrants out for him. And so, because you don't have that contractual relationship, you can't hire, and I've heard other people talk about this before. Oh, somebody should hire a bounty hunter to go get him. That is kidnapping. That is conspiracy to commit kidnapping. Kidnapping, if it goes across state lines, there's a lot going on there. Probably assault. Wrongful imprisonment. You can just pile on charges. It is all bad, no good. So I just want to caution people to maybe engage your brain before you make a social media post. Think about it before you post it. Don't say anything stupid that can get you in trouble. I'm not saying this person's going to get in trouble for it. The odds of that person winning the lottery are somewhere in the slim to none. The odds of Chili getting kidnapped are somewhere in the range of slim to none. But just be careful out there. Watch what you say on social media. I get it that everybody's all hopped up on all these things, but it's not good. So thanks for watching. Have a great day.